Welcome to Lecture 1 for Criminal Procedure for Forensic Analysts, BLM 2008. The topic we're covering together today is Criminal Procedure and Criminal Courts. My name is Mr. Benjamin Ang from the School of Business, Diploma in Law and Management. And I'll be taking you through a couple of things because this is the first lecture. If you're a student of Criminal Procedure for Forensic Analysts, this is the assessment structure that we're going to have for this subject. You will notice that 50% of the subject is coursework and 50% is examinable. The individual assignment and the group assignment are both written projects. Each will be 20%. When are they due? You can check the schedule which has been posted online. Class participation is ongoing. Every lesson, I will be assessing you, each of you, on class participation. So the more you participate in class, the better you will get for this 10%. 10% is worth 1 grade. It can actually improve or reduce your overall grade by 1 grade point. So it is worthwhile to participate in class. And the best way to participate in class is to come for your tutorial prepared. You don't have to know every single answer, but you must have at least tried so that you can ask intelligent questions. And I will track each participant for whether you're making up to no participation at all, which is 0%, up to very good participation, which you can get 10%. So being in class alone, by the way, does not give you any participation points. It helps for your attendance, of course, but to participate, you must really get involved in answering questions or asking questions. And then the exam at the end of the semester will be 50%. As it comes closer to exam time, I'll explain how the exam will be structured, which will be an open book exam. That's good news and bad news depending on how you deal with open book exams, but we'll deal with that nearer to the time. You'll notice there is no mid-sem test, so you are clear during the mid-sem test week. This subject team is one person, that's myself, and these are all the ways in which you can contact me. You can email me, you can WhatsApp or SMS me, you can reach me on Twitter, on Facebook, and even in my office. But all of these will only be answered during office hours. If you send me a message after office hours, I will get back to you the next office working day. Now here are the reference materials. There are 2 statutes or acts which you must have at every lecture and tutorial. This is the Criminal Procedure Code 2010 and the Evidence Act. These 2 are acts that we're going to be referring to at every lecture and tutorial. And because you're having an open book exam, it is very important that you know what's inside your Criminal Procedure Code and your Evidence Act. You will want to bring them for every lecture and tutorial so that you can highlight, flag, and annotate these acts. And then you can bring them in for the exam. If you bring in a Criminal Procedure Code, an Evidence Act to the exam, to the open book exam, which has no markings, no underline, and no flag, you're not going to be able to find the section that you're looking for. You will understand this better after you have actually printed the Criminal Procedure Code. It is a long document. You may want to print it double-sided, 2 to a page, because you are young and your eyesight can still take it. But you will need it regardless, whether you print it single side, double side, 4 to a page, A5 size, A0 size. You will need it in hard copy at every lecture and tutorial because you will want to underline and flag and annotate it. Same with the Evidence Act. There are other acts which I will announce before the specific lectures in which we cover them. Things like the Personal Data Protection Act, things like the Computer Misuse Act. These are things which are relevant to you as a digital forensic analyst. But the one that you need for this course, criminal procedure, will definitely be the Criminal Procedure Code. These are laws which are passed by the Parliament, and I'll explain a bit more about them. But for your use, make sure you bring them. Now, is there a textbook? There is a reference book called Halsbury's Laws of Singapore, and it's a huge like encyclopedia. And the chapter that you want is the one on criminal procedure. This one you do not have to print. Well, if you want to print it, you are free to do so, but it's about 200 pages plus. You may want to just use this as a reference. This is so full of information that you probably will not be able to use it in an open book exam. So you may just want to have a soft copy to refer to. Feel free to print if you want, if you don't mind using 200 pages worth. Anyway, if you do it 2 to a page double-sided, that can divide that by 4. But the reference material, Halsbury's Laws of Singapore, which I said is an encyclopedia, you only need the chapter on criminal procedure. And even the chapter alone, which is 200 plus pages, is you won't need every single chapter. I will be going through the semester which chapters are which parts of this chapter are going to be relevant to you. Now, how do you get this encyclopedia? It's available at library.tp.edu.sg under resources. And on our site, I have also put instructions on how to download it. So that's the structure of assessment for this subject, and also the reference materials that you can use. So we start on our first lecture today, and we want to know what we're trying to learn today. We're going to cover two broad topics. One is criminal procedure and the other one is criminal courts. And I'm going to introduce you to this idea of criminal procedure, which in some countries might be called the criminal justice system. And we'll talk about why we need it, what it's for, and where you find out more about the criminal procedure in Singapore. We call that the sources. We also want to know who are the key parties, the important people in the system. And then we'll talk about describing the whole process from the beginning to the end. This is an overview because through the semester, we're going to go through the individual parts of the criminal justice process. And in the criminal courts, I'm going to actually go through the different courts like the subordinate, which is now called the state, and the supreme courts. I'm going to explain to you the distinction between an original and appellate court and different levels of court. And we're going to end off with identifying the most appropriate court to try or to listen to any given offense. Throughout this lecture and throughout the face-to-face lectures that we will have, we are going to be going through certain questions, and the questions will be in the face-to-face lecture, the questions will be dealt with answered in the lecture itself. So the lecture will not be a full on 2 hours of me talking. But what you will have is you will have segments where you are going to break into groups for discussion, and we're going to work out the answers. And I'm only going to explain the answers in the lecture. So there are also topics which will only be covered in the lecture. We will not be covered in the tutorial, but they are examinable. Moral of the story, come for lectures. Because if you don't, you miss out the answers to the questions, and also you miss out certain topics which are examinable. Right? I cannot force you to come for a lecture, but I can tell you if you don't come for the lecture, you will miss out a big chunk of the subject which is examinable. Because this is an online lecture, I'm not going to stop for you to break into groups for discussion. It's not going to happen. So this online lecture will be faster than our usual 2 hour, or rather maybe 1 hour 45-minute lecture. Right? So this lecture online will actually finish earlier than that. First, let's explain the need for and the purpose of criminal procedure. Criminal procedure tells us how to investigate and to try crimes. Now, I put try in quotation marks because it doesn't mean that we try committing the crime. It means that we try, as in put to trial, the crimes. How do we know what steps to take during the trial? Who should stand up first? Who should sit down first? What documents should you show? What documents must you prepare in the many months before the trial? This is all determined in the criminal procedure. This is all the process, the SOP that you need to do in the process of investigating and bringing the crime to justice. So, what a lot of people are familiar with is the criminal law. The law states what is a crime and what is not a crime. And the law can be found in a statute like the Penal Code. But on the other hand, the criminal procedure is the process by which the criminal offences are investigated and then brought to a trial, which is the word tried. Tried is the verb for bring to trial. And this is found in statutes like the Criminal Procedure Code. So, examples of crimes on the left side: murder, theft, robbery, rape. But criminal procedure is the process by which you investigate a murder, investigate a theft, investigate a rape, and the process by which you bring that particular criminal to trial. So that's the difference between criminal law and criminal procedure. Where can you find out what these steps are? In statutes. Statutes are written laws which are passed by Parliament. So if you ever wondered why do they have these long Parliament meetings which they broadcast on TV and nobody watches, that's why they have it, to vote on things like statutes. And the Criminal Procedure Code was recently voted on in 2010, a complete revamp, so you have it nice and fresh. So speaking of statutes, let's look at the sources of criminal procedure. Because just like you have a reference material, you have the encyclopedia I told you about called the Halsbury's. There also is reference material for criminal procedure in Singapore. So let us look now at the statutes. This is a time when I pause a little bit and you go and check your various statutes, because you look at the Criminal Procedure Code, CPC, and flip to now section 4. When you have looked at section 4 of the Criminal Procedure Code, you will see that the CPC covers all offences under the Penal Code and other offences depending on the written law. That means if you're investigating or you're bringing to trial a crime like murder, robbery, rape, riot, the CPC is what you will refer to know what steps you need to take in investigating and bringing it to trial. There are some offences where no steps have been provided. Section 6 says that the CPC will come in and you use the CPC to determine what to do. There are other statutes besides the Penal Code. The Penal Code, of course, contains all the most widely known crimes, which I mentioned before. There are other statutes called the Misuse of Drugs Act, Prevention of Corruption Act, and many others. These may have their own procedure for investigation and for bringing to trial. In that case, they will override the CPC. So as I was saying, these statutes are written laws that have been passed by the parliament, and these are referred to because they state, when you now refer to your criminal procedure code, they state actually what is the procedure, but sometimes there are gaps because you can look at the section and it might be difficult to understand. And then you need a judge to interpret what it means. Because Singapore has a common law system, you can look at local or even English cases if there are gaps in understanding how each section should be interpreted. So, for example, in the case of Soon Pek Wah and Woon Che Chai, the courts decided that the English hearsay exception will be recognized. I'm not going to explain this now, but I'm going to use this to point out that there's something called the English hearsay exception, which we will talk about in the middle of the semester. In the case of public prosecutor and Knight Glenn, the court also said that American plea bargaining will be recognized in Singapore. So these two particular questions, which you still don't know what they mean, but we'll talk about it later in the semester, were not addressed in the criminal procedure code. But the courts said that they made a decision, we will recognize these particular concepts. And so because our courts have decided it, in future courts will also follow. So if you look at the picture on the screen now, the statutes used to be bound and hard copy. Now they're all available online and searchable. For example, the criminal procedure code that you have with you. The common law is recorded in case reports, and there are examples of case reports which are also available now online, which you can read, in which the judges will write out what happened in the particular case and what the decision was. So these two are materials, primary source materials that you can refer to. For the purposes of our course, because this is not a full criminal procedure course, but rather criminal procedure for forensics, what you'll be looking at is summaries of the case reports, not the full case reports. But feel free to read the whole case report if you want to see the whole story. The statutes can't be summarized. You need to actually read the actual statute. Now let us look at the key parties in the criminal justice system. The person who actually starts the process of bringing a criminal case to trial is the prosecutor. Here you see a picture of the public prosecutor, or as he is actually formally called, the Attorney General. The Attorney General is a member of the government, and he is the public prosecutor, which means that on behalf of the public, the people of Singapore, he prosecutes or brings a criminal to trial. Section 11 of the CPC says he has control and direction of all criminal prosecutions. So he decides who gets prosecuted, and he decides in what way they get prosecuted in accordance with the Criminal Procedure Code. You see, a person can be arrested, but whether he will be brought to trial or whether he'll be let go depends on whether the prosecutor wants to pursue the matter and bring to trial. Of course, he doesn't do all of this by himself. He has a whole team of deputy public prosecutors who he has assigned powers to, and they are the ones who will be in all the courts prosecuting the individual trials. So it is not the police that bring a person to trial. It is the prosecutor who brings them to trial. When you watch this on TV, this is similar to what they call the district attorney or the DA. So there are other prosecutors, because besides the public prosecutor, the boss, there's also a solicitor general who may uh, be the second in charge and who may also take care of major prosecutions. And they have their team of deputy public prosecutors and assistant public prosecutors. All of these are people working in the government. Sometimes, for a high court trial, the prosecutor can authorize an advocate, meaning a lawyer, to prosecute. There are special circumstances in which a lawyer will be asked to take on the role of prosecuting, and we'll talk about it later in the semester. That is for the high court. In the state courts, which is the lower level of court, Section 11, subsection 9 of the CPC says that the public prosecutor can authorize officers from public bodies to conduct prosecution before a magistrate. Let's look at this sentence. First of all, you have just seen a subsection, section 11 bracket 9. You do not pronounce it as 11 bracket 9. You pronounce it as 11 subsection 9. So what it's saying here is that the public prosecutor can say that an officer from a public body, that means if you think about all the different departments of government, there's police, immigration, customs, manpower, NEA. These are all public bodies, and there are legal officers working in all of these agencies, ministries, and departments. The public prosecutor can say that these legal officers can conduct the prosecution, they can bring the case to a trial if they are appearing before a magistrate. A magistrate is one of the levels of judges. This is the second most junior level of judge in the state court. So, for example, police inspectors can do prosecution in the state court in front of a magistrate. Immigrations and customs officers can do prosecution in the state courts in front of a magistrate. And Ministry of Manpower officers can also run a trial before a magistrate in the state courts. Section 11, subsection 10 talks about private prosecutions, where actually private individuals or companies can do prosecution as well. We'll talk more about this later in the semester. As you can see, this is really an introductory lecture because there's so much detail to talk about through the whole semester. That's why you have 14 weeks. How does this private prosecution work? In section 12, it says that the public prosecutor can issue fiat, meaning it can give permission to any person to conduct a prosecution. I'll give you an example. In terms of software piracy, because the matters involved are very technical, normally the software companies ask for this fiat or permission to conduct the prosecution themselves. But to prevent abuse, the public prosecutor can take over the prosecution at any time. That's in section 13. If the prosecutor feels that it's not being done correctly, he can take over. Of course, on the other side of the prosecution is the accused person. And you can look at section 150, initiation of proceedings. In the semester, we will go through things like arrest and summons, arrest warrants, notice to attend court, and there are various rights and duties that an accused person has. Until the point where he is actually convicted or found guilty, we still call him an accused person. We can't call him a criminal because he hasn't been found guilty yet. So he's still an accused person. Article 9 of the Constitution of Singapore, and this is the only time I think I will be referring to the Constitution which is in respect of accused person. Article 9 says the accused person is entitled to be defended by an advocate or otherwise a lawyer. So every accused person is entitled to be defended by an advocate. And if you can't afford one, you can ask legal aid. There is a legal aid bureau that will look for one for you. Now, who is going to decide whether they're guilty or not? The judges. This is the Chief Justice. He is the boss of all the judges. And below him, there is a court of appeal, and there are judges of appeal, the JAs, judges of appeal below him. Below them, there are the High Court judges. Now, you will see this initials appearing after their names, not before. You ask why do the initials appear after the names and not before? That's the way it is. It's law. There are judges who are in the High Court. They are called justice. So and so. So that's why Chief Justice Sundaresh Menon, he used to be Justice Sundaresh Menon. And now that he's been promoted, he's the Chief Justice. There are also judicial commissioners, and these are judges who are there on 1 year contract. They have not been persuaded to leave their very well-paying lawyer jobs yet. So they are on a 1 year contract to see whether they like it. And if they like it, then they become full-time as judges. It's almost like having an adjunct judge. But that's for their 1 year. Judicial commissioners, same authority as judges. In the subordinate court or state court, there are district judges, DJ, not the kind who spins music, but district judges and deputy registrars. Okay. So this is the hierarchy of courts. This will take a while to get used to. I know it's a big diagram. But if you look at the bottom row, that's the state court. The state court has a few sections. The ones that mean the most to you will be the magistrates court and the district court. There's also family court, handle family cases like divorce, adoption, Sharia court, which handles Muslim law, juvenile court, which handles young people, but the ones which you will use the most are magistrates court and state court. So these are the state court level, and you will find the state court in Havelock Road. That's the ones in blue. Now, further up, the ones in purple and red, which is inside the red dots, these are the Supreme Court, the High Court and the Court of Appeal. These are found opposite Funan Center. There should be a better way to describe this. Okay, so there are different levels. And I'll explain to you what these different levels mean. Now you see I put these dotted lines there. The bottom row is original jurisdiction and the upper row is appellate jurisdiction. Okay, let me explain what this means. Oh, I see it's not here yet. I'm going to explain to you the criminal justice system first. So hang on to that thought. Okay, just remember that this is here. Okay, criminal justice process. And I've put in asterisks where I think digital forensic analysts may be asked to come in. Now, if I were to go through all this in words, it's going to be really boring. So hopefully this infographic helps. First, we start with the first information report, right? Here's a witness. She says, I saw Bob commit a crime. So she is going to report it to the police. Call 999. Or if you're in other countries, you call 911. But remember, don't call 911 when you're in Singapore. You don't get anybody. You call 999. The police station receives your call. Or you might go to the neighborhood police post and you give it face to face. They receive it, and that's called the first information report. When they have this first information report, it's actually going to be recorded in the file, take a note, and then the police will choose whether to investigate. Right? So this is a very important report. How it's taken, what information is inside it, who is the one who gave that statement, I saw Bob commit the crime. Then at which point it starts to branch out, because you will see that on the right side, some cases arrest straight away. Some cases on the left must search, must investigate before you can arrest. How do you know whether arrestable straight away or must search first? We'll talk about it next lecture. Okay, so remember on the left side we said some cases must search first, right? So if you need to search first, look at the orange one going down. Some cases you need a warrant to search, meaning you need permission from the judge. So the police will go to the judge and say, please give us permission to search. Then the judge will say, show me your reason. And he gives a warrant, then you go ahead and search. Follow the green arrow. Sometimes you don't even need a warrant, you can go and search straight away. How do you know whether you need a warrant or not? Again, that will be covered in the subsequent lectures. Now, the right side. In some cases, you can arrest first. You can arrest straight away, right? Sometimes you need a warrant. You need an arrest warrant. So the police again have to go to the judge and say, please give us permission. This time it's not permission to search, it's permission to arrest. Then the judge says, okay, show me your reason. But sometimes you don't need a warrant. For example, if you see the guy running down the street carrying blood-stained parang and chopping up people, you don't have to ask the judge for permission. Please, can I have permission? You straight away you arrest the guy. Maybe probably shoot him in the leg or something. So that's a case where you don't need arrest warrant. So how do you know whether you need arrest warrant or you don't need arrest warrant? Again, covered in the next few lectures. This lecture is pretty much a trailer. The rest of it is going to come through the whole semester. So again, on the left side, we're following the search pattern. On the right side, we're following the arrest pattern, right? When you search, you're going to be going through all the documents. And remember that many people in the world still keep things in hard copy, not just digital copy. So you'll be working side by side with police people, right? And then you will be finding stuff. And the process by which you find the stuff, this one is stuff that you should have covered. In some cases, the arrest will take place. The police person will arrest straight away. And sometimes the search, what you discover in the search, will straight away give you the reason to arrest. So it can also cross over. Now, assuming that the person has, in some cases, when you have searched, you may say, Mr. So and so, you need to come to the police station to answer some questions. Okay, you haven't arrested yet, you just ask him to come to answer questions. Sometimes you arrest them first, then you say, you're under arrest, now we're going to ask you questions. Whatever it is, there will be a point in time where the police are going to be sitting down with the accused person in the police station recording the statement. And they're going to say, tell me everything. And there's a whole process by which the police will do questioning and record statement. And if it's done the wrong way, then the statement may not be used in court. So it must be done the right way. For example, hanging the guy outside the window from his feet, his ankles, and telling him, I'll drop you if you don't answer, that is not the right way, in case you were wondering. Okay, so how do we know what is the right way, what is the wrong way? We'll cover that in another lecture. You see a pattern forming? Now, after you've done all your investigation, at some point, you will start to prepare for trial. And thanks to the CPC 2010 edition, there is this thing called the Case Disclosure Conference, where you actually have the prosecution and the defense lawyer come together for meetings, and they will show each other whatever evidence they have, so that there is no surprises at trial. Because really, nobody wants a surprise at trial. The defense lawyer doesn't want to get surprised by the prosecution. The prosecution doesn't want to get surprised by the lawyer. The only person who's interested in having a surprise at trial is the TV audience in the drama. Because in real life, we want everything to go smoothly. The judge also wants things to go smoothly. If you're the accused person, you want to know what evidence is being used against you. If you're the prosecutor, you want to know what evidence the defense has that might show innocence. So, really, seriously, Surprises are only for TV. In real life, we need to show each other everything. Then we can have a proper discussion, right? At trial, evidence will be brought up, and one of the most common questions will be whether a particular piece of evidence can be used or cannot be used, right? So if you discovered something on a particular hard disk, some particular data, the question will be, can it be used or can it not be used? And who will decide? The judge, of course. The judge will be the judge of that. So that's what's going to happen at trial. So talking about trial, have a look at the criminal courts. This is the Supreme Court. It is very nicely situated around the City Hall area, opposite Funan, next to the Parliament. Got a nice flying saucer at the top. You can actually visit and look out. It's got a great view of the city. And let me explain the difference between the subordinate and Supreme Courts. This is the subordinate court or state court. This is in Havelock, near Chinatown Point. It is not as glam, but I can tell you that there are hundreds and thousands of cases being heard here every day. Very, very important court because most cases are going to end up in the state court. Okay, so different courts have different jurisdiction. And Section 7 and Section 8 of the CPC will tell you that there is who can go to the magistrate's court and who can go to the district court. There's extra powers given in Section 9. You see this thing which says first schedule? The schedule is also called an annex or appendix. So that annex or appendix is called a schedule in our acts. And MC is magistrate's court, DC is district court. So these are the sections which will tell you what kind of cases go to magistrate court, what kind of cases go to district court. Okay, Section 9 will tell you that there are extra cases. Let's just look at Section 7 and 8 first. So now some work for you to do. Big question mark there. This is for you to fill in the blanks, because when we step into class for the tutorial, I'm going to ask you these questions. Okay? We're going to go around the room and I'm going to ask questions. So you have a whole week before the first tutorial to prepare this. And you can fill in this by looking at Section 7 and Section 9 of the Criminal Procedure Code. So this is the Magistrate's Court. The Magistrate's Court handles cases of a certain kind. They are listed in the first schedule, 7th column. Okay. You flip to your Criminal Procedure Code and you can see the first schedule, there is a 7th column. Now for sentencing, it can sentence up to a limit of how many years? It can also give a fine up to a limit of how many dollars? And it can sentence caning up to how many strokes? Can it issue the death sentence? All these are found in Section 303. And you need to fill in these blanks, which we will have discussed at the first tutorial. Okay. District Court is also part of the State Court, but this one has more powers. Looking at the blanks again, Section 303 will tell you what's the maximum number of years you can sentence in the District Court, what's the maximum dollar fine, and what's the maximum numbers of strokes of the cane. Can the District Court issue the death sentence? Again, you'll find this in Section 303. The judge in the Magistrate's Court is called a magistrate. I'm sure you could have guessed that. The judge in the District Court is called a district judge. They are more senior to a magistrate. So which one do you think will have more authority to give more years or more fine? So we'll answer that at the start of the first tutorial. There's also a juvenile court. Okay. And I'm posting this thing, the Children and Young Persons Act, on Olive. Extra thing. Who does it have jurisdiction over? You can refer to section 33. What date do we determine the age of the child? We refer to section 33(6). And how do you know what's a child? Between what year and what year? Section 2. How do you know what's a young person? Between what year and what year? Also section 2. So you just need to get the CYPA on Olive or on our other site, and we can move on from there. Okay, so these are all blanks we're going to answer at the start of the first tutorial. I'm going to go around the room and see what answers you have. Juvenile court can try what kind of offences? What are the limits it cannot sentence the accused to? What can it order the parent or guardian to do? So there's a lot of things the juvenile court can do. So this is a special court for young people. And this I'll be asking you at the start of the tutorial 1, and this will also go towards your class participation, whether you can answer or not. Remember there was this diagram I showed you, original and appellate jurisdiction? I'll show you this again. Refresh your memory. Remember the High Court and the Court of Appeal have appellate power, whereas the state courts all are original power. But it looks like the High Court actually has both. Okay, so let's talk about what's original and appellate. The original jurisdiction means that this court has the power to hear a case for the first time. So the judge there says, you come to me first. You can start here with me, right? And you will go to these courts for the first case. The appellate jurisdiction is the one that has the power to review the lower court's decision. That means you can appeal to them. They will review what the lower guy decided. It is not automatic that you can appeal. There are certain criteria. Okay, so the state courts, remember the one I showed you at Havelock, they have original jurisdiction. If you want to start the case there, they will start from there, but you don't appeal to them. After you have appealing means that you've already gotten the judgment, you either found guilty or not guilty. If the accused is found guilty, he will appeal because he's not happy. If the accused is found not guilty, then the prosecutor will appeal. Then they will go to the Supreme Court, which means the High Court first. First level is High Court, remember the diagram? The High Court is special. The High Court you can actually start at High Court for certain kinds of cases. In theory, you can listen to all kinds of cases and can pass any sentence. And you can also hear appeals from the lower courts on particular points of law, or you can transfer cases to the High Court. So the High Court is a special one. You can start there and you can also appeal to there. But the Court of Appeal, the one right at the top, you cannot start there. I think that makes sense. How can you start at the top? You must start somewhere lower. So the Court of Appeal has the Chief Justice and the Judges of Appeal. They can also ask a High Court judge to come in, and it's usually 3 or more judges. Now, the reason for having 3 judges to decide an appeal makes a lot of sense because you want to get a majority vote. If you have 4, then 2 plus 2, you cannot have a majority. Or maybe you have 6, again, it's going to be difficult to decide who's the majority. So once you have an odd number, it's much better. You know who the majority is. Can you always appeal to the Court of Appeal? According to the SCJA, which is the Supreme Court of Judicature Act, which you don't need to read, I'm giving you the summary here. It will only hear appeals from the High Court when the High Court is the starting point. Okay. So if you start at the High Court, then you can go to Court of Appeal. But if you start at the lower court and then you appeal to the High Court, you cannot go further up to Court of Appeal. And this was decided in the case of Ng Chai Hui, which was a 2007 case. Right? And you can see the 2 SLR 106 is where you can find this. It's found in the part 2 of the Singapore Law Reports, page 106. There's part 2, Singapore Law Reports, page 106. Anyway, you don't need to read the whole case. I'm just telling you, in that case, they decided the Court of Appeal can only hear cases from the High Court if the High Court was where you started. If you started lower and you appeal to High Court, you can't appeal again. Section 397 of CPC also says it must be a question of law of public interest. So not everybody can appeal from the High Court to the Court of Appeal. It has to be important. How do we know what is important? Well, in another case in 1997, Prosecutor versus Christopher Bridges said that it'll depend on the facts. Like, I mean, I'm not telling you. We'll see how. In Abdul Salam's case, it said that if it's a question of law, it should be something so important that will affect the outcome of future cases. Okay, that's probably a good indicator that what we're deciding here is so important it will affect other cases in the future. It's not just this guy, this particular accused. It's really got long-term implication. We're going to talk about appeal in detail in one lecture much further down the road. So you can think about it then. So here's something for you to try. It's going to take you some time. If this were a lecture, I would have taken time out now for you to work in groups to find out. But since it's an online lecture, you can take your own time and refer to the Criminal Procedure Code. First of all, I'm going to show you the first schedule. In the first schedule of the Criminal Procedure Code, which is right at the back, it's an appendix. It tells you for what offense under the penal code you will have what kind of implication. And you might want to go and draw your own vertical lines down, because the way that this is done, it is pretty hard to read because there's no lines dividing the columns. But if you just look at column 1, and you can tell it's column 1 because there's a number at the top of the column, it tells you that this is the penal code section. Now you may also notice that when the thing starts to run and you print more pages, the number 1 does not appear anymore. So like I said, you can draw your own vertical lines and put your own numbers at the top of the column. This is perfectly fine. You can bring in annotations, post-its, highlights, draw smiley faces on your Criminal Procedure Code. You can bring it in for the open book exam. Whatever helps you to read it better. Column 1, Penal Code section. Okay, you don't actually know what the sections are because you didn't study criminal law. It's okay. The actual offense is in column 2. So for example, Penal Code section 121 is the offense of waging or attempting to wage war or abetting the waging of war against the government. So that is an offense. So either you're going to be told the offense, the wording, or you're going to be told that it's an offense under section 121. You don't have to memorize this. It's all in the schedule. When you know that this offense has been committed, then you will ask the question, can the police arrest without a warrant, or must they have a warrant? And you will see there further down the second circle in red, they can arrest without a warrant. So if they can arrest without a warrant, straightforward. They don't need to go to the judge to ask for permission. Straight away, go and catch the guy. Now, you see that the next offense below that, 121A, offenses against the president's person. If you ask the same question, can the police arrest without a warrant? The answer is ditto. What does ditto mean? Ditto means you look, it's the same as whatever was said above. So if you look above, it says may arrest without warrant. Okay, so you know. What if you see a ditto below a ditto? Then you look up and you look up until you find words which say may arrest without warrant or need a warrant. Because if you look at column 5, the question is, can the person be bailed or not? And it says you're not bailable. Okay. The maximum punishment is also stated in column 6. And here, if you want to wage war or attempt to wage war, there will be death or imprisonment for life and fine. The last column is what court can hear this besides the High Court? If it can be, and the word triable meaning which court can you have the trial? If it can have a trial in the district court, the word district court will appear there, or the word magistrate court will appear there. In the case of waging or attempting to wage war, it's blank. So you can't go to district court, you can't go to magistrate court, you can only go to High Court. Right? When it's blank, High Court only. If it were possible to go district or magistrate court, then that will be listed in the column. So you see these 3 circles, it shows you how to read this first schedule of the CPC. Okay, now you know how to read the first schedule. Here's your quiz. Referring to the CPC, which is the most appropriate court to try these offences? And I've given you here the section of the penal code, which you can use to refer to column 1, even giving the name of the offence. So from here, determine what's the most appropriate court to try these offences. You need to get familiar with the first schedule because we're going to use it again and again in the next few lectures. So try this on your own, and in the beginning of tutorial 1, I'm going to quiz you on this as well. And that will go towards your class participation marks. So time to think about what did you learn from this lecture. Jot down your ideas and questions that you have and post them in the discussion board, which is going to be up, so that you can have an idea of what did you learn from this lecture, and also if there are questions that you have that need clarification, and if you post them on the discussion board before the next lecture, I can address them in lecture 2. So I will see you at the lecture, the face-to-face lecture in person at LT3 in the following week. So I wish you a good rest of the week.